Hello, my name is attorney Masa Sam Foray, founder of the Foray firm with offices in Chicago and in Houston. And I am back again today to answer all of your Illinois family law questions. So today's question is, I want to travel out of the state of Illinois with my children, but my ex is not agreeing. What should I do? So you definitely have options as it pertains to traveling for vacation purpose out of the state of Illinois with the minor children. Nevertheless, before you file litigation and certainly filing a motion in court asking for leave to travel with the minor children is an option for you. But before you go that route, I would ask you to take a look at your current paperwork. So if you have a situation where paternity has already been established, so we legally have a father on file, and of course, we legally have a mother on file. And that paternity was not only established, but perhaps an allocation of parental responsibilities, which is formally known as a custody judgment, was entered in this case. Then if that custody judgment was written by a good and experienced family law attorney, I bet you that there are two clauses in there that you need to look at closely. You should look at the clause that dictates mediation. If there is a mediation clause in there that says that in the event of a breakdown in communication, prior to filing any litigation, the parties ought to mediate the issue and mediate the dispute, then make sure that you contact a mediator prior to filing any court litigation. The failure to comply with that mediation clause means that your motion that you filed preemptively and prematurely in court might get stricken. Worst case scenario is you might get sanctioned because if your ex has to hire an attorney to go in on a motion to strike and dismiss your prematurely filed motion for vacation because you jumped over the mediation requirement, then you might end up paying unnecessary attorney's fees for that. So first, look at your documents. Also, secondly, if your documents, again, were written by an experienced family law attorney, there should be a clause in there, perhaps towards the end of the document, that describes the mechanism for traveling for vacation purposes. It might have specifically said that you have to give notice in writing 30 days in advance, and that for international travel, perhaps you have to give notice at least 60 days in advance in writing. It might say that you only have to get advance notice and that the other side cannot unreasonably withhold their consent as long as you provide the itinerary, the location, the name, the address, and the contact information for where you will be staying with the minor children. If that clause is in there, then you may not even need their consent as long as you have done what you are required to do under your documents. Now, if there is no paternity established, meaning father has not been adjudicated to be the biological and legal father of the children in the controversy, then all of this might be a moot point. You might not have to do anything at all. You can proceed as you have been proceeding in life, making all of the sole decisions. But if you've been to court before, reference your documents before you run afoul of a motion to strike and dismiss. Nevertheless, just know that once you get to court, if you do have to file for a motion for leave to travel with the minor children, as long as you have disclosed all of the information, as long as there have not been any, violations of the parenting time schedule or the allocation of parental responsibilities, and as long as the vacation is clearly for a temporary vacation and holiday purposes, you're likely to be successful on this type of a motion because courts are pretty clear that once parties are separated, you have the right to liberty, you have the right to the pursuit of happiness, just as everybody else does.